Welcome online and here in person in space, University of Edinburgh. Is my mic okay? Everyone hear me okay? Good. So welcome to, this is the second seminar in a series of 4 that is being hosted by a research program that I'm directing called Music and AI, Building Critical Interdisciplinary Studies, or MusAI, and it's based at University College London, and I'm Georgina Born. And we're doing it in collaboration with our friends from the AI and the Arts interest group at the Turing Institute, some of whom are here today, and we're very happy and grateful that they came in on this with us. So, so here are the 4 seminars. We've held one a couple of weeks ago in London, which was about re-engineering recommendation, prototyping radical interdisciplinarities. And I think there's a recording of that. I don't know if it's up online and available yet. Is it? Not yet, maybe. But anyway, there's a recording. This is the second. Our focus is on music and copyright after generative AI, social, ontological, and legal perspectives. And in a couple of weeks, we're going to Manchester, and we'll hold the 3rd seminar, which is on AI and practice-based research in music and the arts at PRISM, the Centre for Practice and Research in Science and Music, which is part of the Royal Northern College of Music and Manchester Uni. We're very grateful to PRISM for hosting us there. And 2 composers who've been working with us in the program, Erin Einbond and Artemi Maria Giotti, will be presenting work they've been doing using critical perspectives from the humanities in their compositional work with AI. So please join us in person or online. And the 4th seminar brings us back to London on March the 1st at the Turing Institute. And that one is called Towards Radically Interdisciplinary AI Pedagogies. And the aim of that seminar is to present what we're going to do in the 2nd stage of the MusAI program, which is translate the research we've done in the 1st phase. There are 9 projects, I'll show you them in a second, into thinking about new kinds of radical interdisciplinary pedagogies for graduate students training in AI. And the reason, in a nutshell, we want to do this is that we think we're after ethics. Ethics is completely insufficient to the trainings that young AI professionals need now as they go out into the labor market, whether it's in industry or academia. So we want to prototype new interdisciplinary models of pedagogy, and that's what we'll be presenting in the 4th seminar. And you're welcome to join us. Come and write to me. Let's work on that pedagogy together. Today and in all the seminars, our aim is to present our work, which is now about 2 1/3 year in, so we're not at the end, but also to think together. This was a proposal that I learned in Berlin a few years ago at the Metz Musik Festival, when Benno Polzer got us all to think together. And that's what we'd love to do today with you. So here is MusAI. It's funded by the European Research Council and a whole host of additional partners, and it runs from 21 to 26. And there's a website there, WordPress website, which is quite fun. Look at it. Here's a quick overview. It's a 5-year research program looking at the cultural implications of AI through critical studies focused primarily on its relationship with music. Based at UCL, as I said, in the Institute of Advanced Studies and Anthropology, I'm an anthropologist, with links to the Max Planck Institute for Empirical Aesthetics in Frankfurt, Germany, and actually a host of other partners that I won't go through now. But please go look at the website and you'll see all this. Here are the projects composing MusAI. There are 10, including that 2nd stage that I've already talked about. And the previous 9 are going on now. That's what we're doing. We're doing this research. We're in the middle of it. And today, we're going to present work partly drawing on the work that Eric Drott, a colleague based in the University of Texas, Austin, who'll be online, well, is already online, and he'll be presenting shortly. Eric's work, and also my colleague Christopher Haworth, his work, based at and Chris is at the University of Birmingham. So once again, there are explanations of these projects. All of this is on the website. I hope you'll go and take a look. So why this program? The rationale is that despite growing academic and policy work on the social and ethical implications of AI, no major research initiative, when I put the proposal in, yet examined AI's cultural implications, which of course are currently exploding around generative AI, which is one of the focus today. So in this context, we take music as a medium with a long history, of course, of relationship to AI, through which to initiate a field of critical interdisciplinary studies looking at AI's implications for culture. And in particular, we're interested in critical research on AI music. A lot of money, as you will know, a number of you, is going to artistic research, a lot of technological and scientific development around AI music, but much less focus on critical research, which is our orientation. And critical perspectives are not just there to be negative, they are there to help seed entirely new directions of research, not only in AI design, which is what we're doing in the recommendation project, but also in music making. And to achieve this, we argue that new approaches are required that cut across entrenched disciplinary, epistemological, methodological divisions. And so, for example, we are supporting computer scientists to be in rich and sustained dialogue with artists, musicians, is to prototype new radical forms of interdisciplinarity for AI music and for the digital humanities. And as I said in the second stage, we want to turn this into new pedagogies. So let's turn to today's topic, generative music AI and these social, ontological, and legal questions. We'll be going over this a lot. And the structure of today goes like this. I'll speak for another 20 minutes or so. Eric Drott will then, he's online, will speak and present a paper, and then Chris will present too. And we hope we'll have close to an hour for Q&A and discussion. We really welcome that. We then have about a half an hour break, and there's a little bit of coffee, food, and stuff over there. And then we have a performance, special bonus for those of you who's working with me on one of the projects, and Jules Rawlinson are going to give us a performance. And we're very grateful and look forward to that a lot. So where do we begin with these questions? I'm going to start by just kind of posing a series of questions that we'll be looking at sort of round and round, I think, in the next hour. What constitutes a work when multiple automated recursive processes of citation and derivation lie behind the production of a musical work or event? And who should be the subject of any claim to its title? Must that subject be human author? Could it be machine? Or should it be hybrid, human, non-human? How should distributed ownership be attributed if we understand works as products of many forms of labor in AI, and when creative labor embodied in the data feeding into an ML, a machine learning generated work, has become concern? My mic seems to be going on and off a lot. Is it all right? Can you still hear me? Good. We could ask which features of musical sound merit being protected, melody, harmony, vocal likeness, and which do not. perhaps timbre or style. What alternative ideas of the object and the subject of law could be incubated in light of AI music systems whose creative outputs are irreducible to a work or one creator? Does copyright law incentivize musical originality after AI or curtail it? And how can originality and quality be judged and regulated for in the era of generative AI? And finally, I think the big kind of question haunting us in the room is generative AI accelerating our recognition that copyright, that is, the propertized allocation of rights in music as a commodity, is this an outworn paradigm, one that's not only impossible to enforce, but increasingly politically and philosophically discredited. So, as I said, 3 presentations, myself, then Eric, then Chris, and just for those who are interested, there are some readings that we're drawing on that you might like to look at or follow up at a later point, but don't have to. So I'm going to propose to start that today, at least, we're going to offer you kind of 4 probably necessary analytical perspectives in this space. We should be concerned with the macro environment, the evolving political economy, platform capitalism, the evolving technologies, the industry structure of music and of AI, evolving legal frameworks, social and legal norms. And Eric's presentation will touch on some of these things, actually, probably a completely new dimension of this macro environment. We should also be concerned with the kind of bottom-up, with micro perspectives from key actors, musicians, creatives, labels, startups, their experiences, their interests, their attempted interventions and innovations. And I think Chris's paper will touch, in a sense, on some of this. I'm going to touch on the 3rd and 4th. In the 3rd, I think, as I've already indicated, we need to concern ourselves with the kind of key ontological categories at work in copyright. And I'm going to turn to a body of literature from anthropology, which has for some time been deconstructing these kind of ontological foundations of copyright law. And it's been accompanied in this by critical cultural legal studies, series of figures, Rosemary Coombe and others, who have done really important work, and also aspects of STS, science and technology studies, all of them interested in problematizing these kind of normative underpinnings of IP law. And I'm going to end today by looking at some work from sort of legal theory, quite speculative work, that is thinking about sort of new post-copyright normative approaches, which I think are quite germane to us as we rethink music after generative AI. And in particular, there's a spate of work on proposing new kind of ecological and collectivist models of control and redistribution in relation to cultural works. So for the next couple of slides, I'm going to draw on and refer to a wonderful paper of Eric's that I had up on the list there from 2021 on questions of copyright. And I'm just sort of riffing on what's in the paper. I mean, for a start, Eric gives us fantastic material to ask the question of, what is a musical work after generative AI? And he identifies 3 kind of ways in which the music itself is being radically transformed. The first way, music is not for direct consumption, but is instead, of course, becomes production music, is marketed to other cultural producers for use in games, adverts, film, TV, online web content, and so on. And often generative AI is in there. Second type of AI music startup is targeting consumers. And here AI is enlisted, of course, for personalizing music. Tracks can be remixed on the fly in response to changes of environment or actions, times of day, or new music is generated in real time. And a third example he gives is a kind of shape-shifting where music sort of adjusts to different listening situations. As he says, the same track heard at the beginning of the day may be rendered with a mellow acoustic arrangement, while the very same track heard later in the day when you're at the gym can be transmuted into an up-tempo EDM remix. So just some examples of the kind of transformations that are going on. And then a series of comments Eric makes on some of these key ontological problems, issues, about authorship. He says it's not clear that some of these AI music startups, Amper, JukeTech, and so on, have a title to the music their AI systems generate, even though their title to the AI systems is unimpeachable. On originality, he comments, with neural networks, evolutionary computing, and other techniques able to extrapolate from inputs to produce unpredictable outputs, this is Eric's opinion here, the likelihood of satisfying the originality criterion in copyright law is greater still than in earlier paradigms. On the humanness of authors, he says perhaps the greatest hurdle is the default assumption that creators of copyrightable works be humans. In the US, actually, this isn't formally enshrined in law, though the agency administrating copyright refuses to confer this status on works produced by non-human actors. So very interesting kind of complexity there. And finally, on copyright and the drive to propertize AI music, he comments, there's still the possibility that for lack of an identifiable human author, AI-generated works will default to the public domain outside copyright. Indeed, given the state of copyright law in the US and the EU, this is what should happen. To date, however, the principle has yet to be put to the test, but it's precisely to forestall an eventual finding that might judge AI-produced art to be in the public domain outside structures of property, that the legal community has sought urgently to identify some candidate, any candidate, who can be designated the author of such works. So this is just to kind of give us some of the landscape. I'm going to turn to the anthropology of property that I mentioned earlier, which is pretty interesting because way before where we are now, it was already deconstructing these key categories of ontological categories that underpin a copyright and IP. And they point out, and I'm drawing here on this fantastic book called Property in Question, edited by Caroline Humphrey and Catherine Verdery. And they point out that there's a very culturally specific ideological conception of property at stake here, prevalent in Euro-American law, based on a person-things relation nexus, as well as the language of rights. And they pull out each of the elements in this nexus, right? Questions concerning the person, the thing, the subject and object of property law, that's inherent in the view of property as relations among persons by means of or with respect to things. And ontologically, they say we should question these notions of person, thing, and indeed their relation. Property theory, they comment, assumes that persons are bounded units consistent through time, but what if they're not? And we could turn to the work of Marilyn Strathern on the individual, go there if you want, and other kind of post-structuralist accounts of the subject in support of this questioning. They say if we call into question the unity of persons, then what is a thing? Is it possible that things may consist of assemblages of social relations rather than antedating those relations that kind of cluster around the thing in the ontology of property? And even property relations can be problematized. They say, what kinds of relations does property include? It's assumed that persons and things are separate. So establishing a property relation means overcoming but affirming that separateness. Some persons are united with the thing as against others who are excluded. Now, this exclusion quality is something we'll come back to with the critical legal studies people later. It's a big deal. But how, say Humphrey and Verdery, what about relations of consubstantiality? It's a well-known term in anthropology, and what it's about, for example, in totemism as a practice, is when persons and things are not deemed separate, but are seen to participate in one another. So we can ask in this light, how does generative AI in music reconfigure the basic ontological categories that I've just been talking about? And they go on, Humphrey and Verdery. They insist that intrinsically, property discourses are actually about social relationships. And I need to put in a sidebar here for those of you who don't know anthropology, that by social relationships, they will include the economy. The economy is a nexus of social relationships. So they say the question of value is central to any property relation of persons and things. No one wants to establish social relationships or an economy with respect to things of no value. So when is the language of property used? Well, they draw from the chapters in the book and say that it's associated with processes of individualization, personalization, commodification, and the narrowing of property to mean ownership. And this kind of inquiry, they say, shows us how property language is actually commonly used as an instrument in political struggle. And they continue commodification. Process of commodification imply money values being assigned to things previously thought immune to them, pointing to the complexities of trying to determine commodity values and ascertaining owners to whom they apply. So we could ask about generative music AI, what we've seen so far, my quotes from Eric's paper, is that generative AI is about the innovative genesis of more and more previously unimagined ways of carving up musical processes and experiences to assign monetary values to them. And they comment, when culture, we could say music, that has not been commodified enters into the circuits of capital accumulation, the question becomes, what kinds of returns or reparation should people receive? And they comment that this is often framed as compensation, the promise of a future return. So we could ask about generative music AI, what kinds of compensation or return should be made available? And finally, about value, they comment, value can be a quality not of single objects, but of networks of things, people and institutions. So value can be lost, but actually also made, I would add, by disembedding things from their previous network. So one of the things we're seeing with generative AI is the disembedding of music from previous modes of its circulation, of its existence, and a kind of transformation, re-embedding in new networks and situations. So we could ask, what kinds of value are being generated, assessed by whom and in whose interests in generative music AI? If earlier notions of musical value are being overturned and transformed, what are they being replaced by? And finally, from this body of work, I want to pull out scarcity. So they make the standard comment that information, we could add culture, poses special and interesting problems for thinking about property because the technologies of the information age make it abundant rather than scarce. And one way to capture information is to create IP rights in it, which make it scarce. Now, precisely this insight encourages us to wonder at the economistic assumption, they say, that scarcity is the basis of property rights, a view presupposing that resources are naturally scarce a priori, rather than being made scarce only within a given system of values and power relations. And they comment, analysis shouldn't posit scarcity as a condition of creating property rights, but instead make the relation of scarcity to property and to music a question. So one of the big questions for us these days is, does generative AI in music and the arts herald the end of scarcity in music and the arts? Or we could say, how will scarcity be recreated in music, AI, if it's so central to music's propertization? Right, in the final minutes, I want to turn to critical legal theory and just bring you some interesting brain teasers from this current thinking in critical legal theory about where next, where do we go after copyright? So there's interesting that there's already a kind of presumption around in this domain that copyright and IP in general are in crisis. And I want to talk about the work of two theorists in particular, Séverine Dussolier, who is from Sciences Po in Paris. And the paper I put up in the list earlier is her talking about copyright beyond, or post-copyright beyond exclusion. And she sees this as the way, a precondition for strengthening the public domain. So one of her principles is that she's unhappy. She's completely dissatisfied with available solutions to these problems, Creative Commons, copyleft, because they still hold on to, if you like, a kind of neoliberal conception of authorship predicated on the individual. And instead, she takes Marx and others as a source for her fundamental argument about the intrinsically collective and social nature of creativity, and argues for a new legal paradigm for creative goods that doesn't rest on what she calls the romance of individual authorship, nor the romance of the commons. And in this quote, she's talking about res communis, which is a concept from Roman law that long predates our idea of the commons today. And I gather it's kind of resurgent as an idea in environmental law, where it's helpful in kind of eliding the human, non-human distinction. And Dussolier comments, she says, the notion of res communis highlights the collectiveness, hence inclusivity of entitlements to use the public domain. By definition, the public domain can be used by anyone without infringing copyright. It thus creates equal and symmetric entitlements in all users. This positive approach insists on the inherent value of the public domain as providing raw material for further creation and innovation, and begs for a legal regime enabling its preservation. Now, I just want to point out to you what many of you may already be thinking, the kind of irony in here, because her ecological and collectivist perspective on post-copyright, which proposes the dissolution of individual authorship and the decommodification of culture, music, is entirely consistent, one could say, with what generative AI is doing to music. So I think there's a really important question for us, and one that I hope to pose to her when she comes to an event we're going to host in November in Stockholm. And that is, how useful is this paradigm for generative AI in music and the arts? What's the critical edge here? Do we have to be kind of more careful about collectivist paradigms? Here she is, she extols this. She says we need many more new experiments in licensing. Here's one, CC4R, which apparently was made by a collective, a reimagined copyleft license geared towards reuse or remix scenarios in which collaborators don't want to contribute to oppressive arrangements of power, privilege, and difference. Here's Constant, the group who developed it, who have a very interesting website, actually, with techno-feminism, anti-colonial tech, and so on happening there. And just about to end, for a very different, not very different, but an interestingly different and instructive normative stance I turned to a Cuban legal theorist that I came across 10 years ago when we were working in Cuba and held an event actually on IP in relation to digital culture in Havana. And this is Lilian Navarrete. And the key shift, I think, is that Navarrete starts out with an understanding of the social totality as fundamentally riven by inequalities. And so she makes two key points about Cuban collectivist attitudes to copyright law, where she says rethinking law is itself a creative collective act. The first point is that the collective, not the individual interest, is primary. And her second is that the key goal is the provision of conditions within which creativity can flourish. In our times, she says, it's necessary to guarantee a protective space prior to creation, such that the latter can take place under favorable conditions. And to quote some more, she says, in forums calling for the homogenization of intellectual property regulation, both in a multilateral and bilateral setting, we need to demand the participation of organizations able to defend the rights of the most excluded sectors of society, such that their social interests are also taken into account. The protection of author rights must remain subordinate to the social necessity of permitting the broadest possible dissemination of science, technology, education, and culture. So that's a very interesting perspective from Cuba. And to end, here are some sort of not taking points, talking points that I thought we might want to have in our heads as we go forward. So this shape-shifting, this continuous shape-shifting in what music is, the very ontology of music that we've touched on earlier. The question of recompense to musicians, to artists, to creators. Do we need new models? What kinds? Put a few candidates up there. Living wage, benefits, salaries. Do we need to be concerned with the sustenance of a professional creative community as opposed to the participatory model that is so commonly espoused today? All of us are creators. Do we have to be thinking about non-humans as creators, and if so, how? What about these collectivist or ecological models of distributed creativity? Can they inform, post-copyright reuse licenses? Or, and this was actually Dussolier's own kind of preference when discussing this in a panel, she was for what she calls expressions of preference for reuse of material. And she points out that this is a mechanism that can be collective as much as individual. And I was just laughing today, my final couple of points just turn on a report from The Guardian this morning saying that the government is deciding to do absolutely nothing right now about regulating AI, and that on copyright in the creative industries, 1/10 of the British economy, effectively they held some meetings between the Intellectual Property Office and AI companies and rights holders to try to find a way forward on text and data mining when AI models are trained on existing materials, music and books and so on. And in short, the group of industry executives was completely unable to agree on a voluntary code of practice. So they've sent it back to the Department of Science Technology. Great news. That's it. Thanks. And I think Eric is going to talk to us now online.
Yes. Let me first share my screen. Go. And Everybody can hear me, both online and off? Okay. So first of all, thanks to Christopher and Georgie and the folks over there for organizing this all. Yeah, I'll just dive right in for the sake of time. So, a lot of ink has been spilled about Heart on My Sleeve, the fake collaboration between Drake and The Weeknd that went viral in April of 2023. I'm not going to rehearse the many debates the track has engendered since its creator, Ghostwriter, uploaded to TikTok last spring. But one point that virtually all the commentary has agreed on is that the track constitutes something of a wake-up call for the record industry. By showing how easy it was to emulate an artist's distinctive vocal timbre by means of readily available off-the-shelf machine learning technologies. The song illustrated the challenges the industry faces in keeping such deepfakes from proliferating unchecked. The fears that Heart on My Sleeve seem to crystallize, fears that AI present an existential threat to the record industry's business model, were given vivid expression by the 15% drop the Universal stock valuation suffered in the first quarter of 2023, driven in part by investor concerns about the threats posed by AI. Taken together, generative AI and vocal deepfakes seem poised to erode the value of this or any other record label's core assets, its vast catalog of master recordings on the one hand, and the roster of artists it has under exclusive contract on the other. Beyond the immediate effects sparked by the viral success of Heart on My Sleeve, just as important were the legal, political, and legislative responses it's either engendered or helped to accelerate. These include lawsuits that large owners of music rights have filed against certain AI companies, such as the one that Universal, Concord Music Group, and others brought against Anthropic in October of last year, on charges that the latter engaged in massive copyright infringement in training its large language model, Claude. Or it takes a form of advocacy efforts undertaken by groups like the Human Artistry Campaign, a recently formed coalition that brings together performing rights organizations, musicians' unions, industry trade organizations, among others, around the shared goal of, quote, ensuring artificial intelligence technologies are developed and used in ways that support human culture and artistry and not ways that replace or erode it, end quote. Or it could take the form of legislative initiatives and to target the sort of voice models used by Ghostwriter, such as the No AI Fraud Act, currently under consideration in the U.S. House of Representatives, and I'll come back to this bill a bit later on. What effect these public efforts will have in shaping the legal, social, and institutional space in which music AI develops remains to be seen. But what I'd like to focus on in my presentation today are the less visible but no less consequential private arrangements currently being negotiated by large owners of music rights on one side and large tech companies on the other. The former include major labels and publishers, but also private investors who've bought up song catalogs in recent years. Figuring prominently among the latter are upload platforms like YouTube and TikTok, which are not only active in developing their own music AI technologies, but also importantly serve as key intermediaries for the uploading and dissemination of AI-generated music. And recall that TikTok was where Heart on My Sleeve was originally posted. What these arrangements promise to intensify is a process already underway for some time, whereby policymaking, regulation, and enforcement around issues of intellectual property are being outsourced to privately owned entities. And while my comments today are going to mainly address these issues as they relate to US law, the effects of these private agreements being forged between platforms and major rights holders are likely to be global in their reach, given the transnational scale at which both sets of firms operate. So to begin, let's consider YouTube's rollout of a suite of AI-related policies and tools in the second half of 2023, formulated in consultation with Universal and other unspecified music partners. In the statement publicizing the launch of YouTube's new music AI incubator last August, CEO Neil Mohan described this and other AI-related initiatives as being driven by the platform's desire to strike a balance between empowering creativity on the one hand and maintaining a commitment to responsible innovation on the other. In terms of AI's potential to foster and not supplant human creativity, Mohan noted how a select group of UMG artists, including Don Was, D4VD, Max Richter, and the estate of Frank Sinatra, had signed on to work with the incubator. The goal, Mohan explained, was to, quote, gain insights on generative AI experiments and research, and thus to better understand how these technologies can be most valuable for artists and fans, end quote. On the side of responsible innovation and the appropriate protections that AI's development necessitated, the press release was much more vague. For the moment, it simply referred to the platform's, quote, strong track record of protecting the creative works of artists, with YouTube's proprietary rights management technology Content ID offered as evidence of its prior success in protecting the interests of rights holders. It was a few months later, in November, that these sketchy comments about AI safeguards were more fully fleshed out. Among the measures YouTube said it would put into place to minimize abuse of AI content were new labeling requirements, which would require uploaders to indicate if a video is synthetic or not, as well as a scaled-up deployment of AI technologies to assist the work of content moderators. But for musicians in the music industry, the most significant new policy was one that would allow them to, quote, request the removal of AI-generated music content that mimics an artist's unique singing or rapping voice, end quote. Rights owners' ability to bar the upload of unofficial vocal deepfakes wouldn't be absolute, however, as YouTube noted that it would balance rights holders' claims with free speech and fair use considerations. Moreover, the ability to make such requests would only be made available to artists who had already agreed to take part in YouTube's AI music incubator, though the platform indicated that it would open up the incubator and thus access to the takedown procedure to other artists in coming months. Driving this new notice and takedown policy is the fact that the sort of vocal emulation featured in the Heart on My Sleeve isn't covered by US copyright law. Only individual compositions and recordings are eligible for copyright protection, since both can be counted as, quote, original works of authorship fixed in a tangible medium of expression, the definition enshrined in the US legal code. A performer's distinctive style or vocal timbre, dispersed as it is across an entire body of performances and recordings, doesn't satisfy this core condition. To the extent that these key aspects of an artist's musical identity do enjoy at least some protection, it's via an entirely different legal doctrine governing rights to publicity. However, in the US at present, the latter is governed by a patchwork of state-level laws. There doesn't yet exist at the federal level legislation that would give individuals control over how their name, likeness, or image may or may not be used by others. With regard to AI-generated music, this separation of publicity rights from copyright is consequential. In particular, provisions in the 1998 Digital Millennium Copyright Act, or DMCA, which govern platforms hosting user-generated content, only address the liability issues raised by copyright infringement, not impersonation, vocal or otherwise. According to Section 512 of the revised Copyright Act, platforms would be shielded from copyright infringement claims, provided they act expeditiously to remove infringing content once notified of its existence by rights holders. Thus, a video posted to YouTube alleged of violating copyright can be subject to a takedown request under this provision, while a video featuring an AI-generated vocal imitation would fall outside its scope. In the case of Heart on My Sleeve, the composition was original, and no recording of Drake's or The Weeknd's was directly reproduced. Indeed, the only reason why YouTube and other platforms were able to remove the song as quickly as they were was because of the short producer tag included at the video's opening, which did copy a bit of recorded sound and therefore fell afoul of the DMCA's provisions. So it seems clear that YouTube's new policies governing AI-generated imitations is modeled on the DMCA, seeking to expand its regulatory regime to cover a set of circumstances that go well beyond what the law's drafters could conceive of in the late 1990s. Or still more likely is that the policy is inspired by what certain legal scholars have dubbed DMCA Plus, that is, the kind of privately negotiated licensing agreement that many rights owners and platforms have reached and that has largely superseded the DMCA in practice. Either way, the new policy continues a process set in motion by the DMCA's safe harbor provisions, one that effectively privatizes IP regulation and enforcement. Under both the DMCA and DMCA Plus agreements, whether or not a claim of infringement results in the removal of an upload is ultimately left in the hands of a private body. The template thus established, one subsequently adopted elsewhere, including in the EU, was one in which online copyright disputes wouldn't be adjudicated publicly in a court of law, but would be decided privately by the owners of commercial platforms and the rights holders they are contractually obligated to serve. Confidential licensing deals between platforms and rights owners have further entrenched what legal scholar Yin Tang has dubbed the privatization of copyright. DMCA Plus agreements go well beyond the enforcement of infringement claims, also creating new substantive rights, mainly to the benefit of major rights owners, while eliminating other rights, mainly to the detriment of ordinary users. What little information has been publicly divulged about these agreements suggests that they minimize fair use, despite the fact that the DMCA charges platforms with factoring it into their takedown decisions. This abrogation of fair use makes economic sense for both rights owners and platforms. For rights owners, it promises tighter control over their IP assets, while for platforms, it rids them of the labor-intensive and thus costly work of adjudicating claims. Under the new regime of privatized copyright, the default presumption is that any unofficial reproduction is an illicit one. As regards the creation of new rights, primarily to the benefit of content producers, this can be seen in the more expansive range of objections that YouTube allows rights holders to lodge against content they wish to see removed. For instance, even though moral rights are only observed in a vanishingly small number of contexts in US law, the takedown policies instituted by platforms effectively extend such rights to artists and rights owners with very few restrictions. As Tang notes in reference to a leaked contract between the major labels and Meta, the parent company of Facebook and Instagram, the agreement made it possible for rights holders to request a takedown for nothing more than a bona fide songwriter objection. Hence, despite there being no federal cause of action for moral rights in the US, such rights are now being observed at scale under the terms of the new private copyright. And this brings us back to the guidelines YouTube has recently issued for how it will deal with AI-generated content, including vocal deepfakes. Much as its prior DMCA Plus licensing agreements resulted in a de facto expansion of copyright, in a similar fashion, the new guidelines governing AI-generated content expand personality rights beyond what is currently enshrined in law. Here, too, we can see how the creation of enforcement of IP regulations is being usurped by private corporate actors. What YouTube's policy institutes is a de facto, if not de jure, extension of IP protections to a domain hitherto beyond its pale. Some portion of the bundle of rights granted to IP owners, the right to exclude and the right to derive profit, are extended to those who can claim ownership over a performer's vocal likeness. And yet this expanded suite of protections is unevenly applied, given its restriction to only those artists who consent to be subject to YouTube's AI experiments. Furthermore, while YouTube avows its commitment to free speech and fair use exceptions, whether or to what extent the company will make good on this vow is unclear. Precedent gives us little cause for optimism, given the way fair use has been hollowed out in YouTube's implementation of its takedown and content ID systems. But just as troubling is that there will be no way for us to know one way or the other. Under the new guidelines, such critical determinations will be made behind closed doors, out of public sight or scrutiny, making the platform and the rights holders it's partnered with into unaccountable arbiters of IP law. So at this point, it's necessary to note that while YouTube has moved quickly to establish this new form of privatized IP, lawmakers have not been idle. On January 10th, 2024, so just over a month ago, or just under a month ago, a bipartisan group of legislators introduced a bill in the US House of Representatives, the No AI Fraud Act, which would expand voice, likeness, and image protections at the federal level in response to the potential harms posed by AI-generated emulations. Notably, the House bill cited hard on my sleeve as one example of the sort of practice it would seek to rein in. Equally notable is that the proposed regulations share much in common with YouTube's guidelines, at least in their broad outlines. The bill would likewise expand personality rights and would do so at a federal level, while leaving space for fair use and free speech exceptions. However, even if this bill should pass into law, it isn't likely to render moot YouTube's and the copyright industry's inroads into IP regulation and enforcement. True, the bill would permit individual artists or their representatives to bring civil suits against perpetrators of vocal deepfakes, with fines of up to $5,000 per infraction, plus punitive damages and attorney's fees. But critically, this legal remedy would only come after the fact. The only way it might inhibit AI deepfakes from the outset is through the disincentives the law's stiff financial penalties create. Absent from the bill in its current form are any ex-ante means by which rights holders can preempt the circulation of derivative AI content online. But what the No AI Fraud Act admits is what YouTube's new AI regulations and detection tools bestow. Important in this regard is a new filtering system YouTube has unveiled, SynthID. While closely on Content ID, SynthID promises to watermark audio generated by means of AI. While still in its early stages of development, if SynthID follows in the footsteps of its precursor, it will likely function as a tool by which large owners of rights can restrict the upload of AI-generated content in advance, with little recourse for user objections based on fair use principles, or the very strong likelihood that at least some percentage of the uploads might get misclassified by SynthID. So what conclusions can we draw from the new policies that YouTube has forged in partnership with large rights owners like Universal? For one thing, they reframe how we should understand the ongoing legal wranglings between large rights owners and AI companies. Rather than a death struggle pitting one against the other with the fate of either copyright or AI hanging in the balance, which is how they're often framed by both the companies in question and by the mainstream press. Just as likely, these skirmishes are just a prelude to some kind of negotiated settlement. Viewed from this angle, the flurry of lawsuits brought by major rights owners are simply one avenue through which the parameters of such future agreements will be hammered out. Another, more hardball negotiating tactic can be seen in Universal's decision last week to pull its catalog from TikTok, accusing the latter of sponsoring artist replacement by AI, end quote. In a way, the current situation recalls a period in the late 2000s, when many of the now dominant streaming services were first coming online. Companies like Spotify and the precursor to Deezer were likewise sued by the major labels, though not with an eye towards shutting them down, as earlier had been the case with Napster and other file-sharing services. Rather, the point was to impose licensing arrangements that heavily favored the interests of the major labels, granting the latter a revenue share, guaranteed minimum payouts, discounted ad space, and equity in the young companies, among other things. From this perspective, whatever threat vocal deepfakes and generative AI pose to the IP assets of major rights owners is offset by the way they're being used as a pretext for a further expansion of IP protections beyond their already very broad scope, an expansion, moreover, that's being undertaken with little or no public oversight. That AI may be less a threat than an opportunity for owners of music rights can be seen in the way that UMG's market cap rebounded in the latter half of 2023 after its initial decline, when there was a general recognition among investors of all the sort of commercial opportunities that the new technology opened up for them. It can also be seen in other partnerships UMG and other large holders of music rights have forged with certain AI companies. A case in point is the licensing agreement that both Universal and Warner have entered into with Indel, an AI startup working in the music health and wellness sector. Under the terms of this agreement, Indel can use stems derived from a handful of tracks in a label's catalog to spin out new songs, not new songs, but what Indel dubs new soundscapes, designed to improve listeners' focus, relaxation, or sleep. An example of the fruit born by this collaboration is provided by three remixes of Roberta Flack's 1973 classic, Killing Me Softly with His Song, which Indel released last October. Elements of the original are sampled, filtered, time-stretched, rearranged, and otherwise processed to transform the roughly 5-minute-long original into 3 30-plus minute albums using quote-unquote scientific principles to tune each of these new albums to the different functional contexts they're intended to serve. Far from upending the legal basis upon which music's treatment as private property rests, Remixes like these show how AI can be used to either create new forms of musical property or extract additional value from existing ones. So in the earlier paper that Georgie cited in her presentation, one of the arguments I made was that copyright wasn't particularly well suited to address the epistemic and ontological challenges raised by machine learning-based systems of generative AI. And this is largely because of copyright's institutionalized commitment to the individual, be it the individual author, the individual work, or the individual rights holder, which I would argue sits uneasily with machine learning's dependence on data in the plural, and more specifically on the sub-individual features and the super-individual relationalities that emerge across these data. Yet the partnerships that Universal has entered into with YouTube and Warner with Wendell make it painfully clear that just because copyright is ill-equipped to regulate machine learning, that doesn't mean that it can't or won't be imposed nevertheless. Important here are just questions of power. Indeed, logics of propertization and enclosure appear to be at the center of the accumulation strategies that many AI companies are currently pursuing, with machine learning serving as a mechanism by which the collective cultural knowledge embodied in a given corpus of texts, images, or sounds can be readily appropriated by private interests. On the one hand, legal contests between AI and music companies over infringement are a matter of determining precisely which of these claimants will be entitled to engage in such appropriation and how the surplus will be divided between them. On the other hand, private DMCA plus style agreements between AI and music companies threaten to enclose not just the cultural commons by reducing fair use and other exceptions to IP restrictions, but also to privatize the very legal apparatus by which acts of enclosure are carried out and legitimized in the first place. Meanwhile, partnerships like those that UMG has forged with YouTube or Warner with Wendell point to how AI may not threaten, but help to entrench existing regimes of IP ownership, either by extending it in practice or by harnessing creative AI in a way that seeks to iterate existing properties and the revenue streams they generate ad infinitum. If Wendell's Roberta Flack remixes are anything to go by, whatever else generative AI may be good at generating, one thing it promises it brews in abundance for rights owners is an ever-expanding range of licensing opportunities and occasions for the extraction of economic rents. Thank you.
Thank you very much, Eric. I wish our sound quality had been better in the room, but I was going to say maybe someone could go and hit the treble, but anyway, it's over. And now, Chris, you're going to.
Yeah. I'm just wondering about sitting down. Can people hear me fine if I do this? I think they can. So I'll say again. You're a bit quiet. I'm a bit quiet. Okay, I shall project. So. And just a note for the people listening online, after I've finished speaking, there is a question and answer period of about an hour, as Georgie mentioned. If you were able to post your questions into the chat, and then we'll read them out in the room, that's how we'll do it, I think, rather than spotlighting you individually to speak. So if you hold any questions until I've finished and then dump them into the chat, I think that's the way to go. So lots of synergies with the things that Georgie and Eric have brought up. I'll dive right into this. In June of this year, Paul McCartney announced that he and Ringo Starr were working on a new Beatles track based on a John Lennon demo from 1970. He said, "When we came to make what will be the last Beatles record, it was a demo that John had. We were able to take John's voice and get it pure through this AI, so that then we could mix the record as you would normally do." The mention of AI in the statement caused alarm among some Beatles fans, prompting McCartney to clarify, quote, We can't say too much at this stage, but to be clear, nothing has been artificially or synthetically created. It's all real and we all play on it, end quote. Later, Ringo Starr intervened with a more direct reassurance for the fans, quote, "We would never fake John's voice." Now and Then was released at the start of November of last year to much fanfare in the music and entertainment press. As the studio explained, AI was used to solve a problem producers initially encountered 30 years ago, when the surviving Beatles, then 3 of them, set about creating a posthumous collaboration with Lennon based on the same 1970 demo cassette. During those sessions, 2 tracks had been salvaged and completed: 1995's Free as a Bird and 1996's Real Love. Now and Then, however, had proven too difficult to clean up using noise reduction methods based on short-time Fourier analysis. It was not until neural network-based source separation methods began to produce satisfactory results that the project could be reopened. Using a tool called machine-assisted learning, shortened to MAL after the group's personal assistant Mal Evans, and designed by Paul Samaragdis at University of Illinois Champaign, the spectro-temporal profiles of guitar, background noise, and voice could be directly modeled rather than approximated and then isolated or removed. This allows the production team to remove the sound of a pernicious television set in the background that was in the same range as the vocal. New parts were then added by the living Beatles, which were recorded and produced by Giles Martin, George Martin's son. And added to this patrilineal patchwork was a not new but not as old recording of now deceased George Harrison, which had been recorded at the first posthumous recording session in 1995, but discarded when the group abandoned the idea. According to McCartney, this was on Harrison's insistence, who called the track "fucking rubbish." Finally, a garish video was created, superimposing Starr and McCartney into a studio with Lennon and Harrison from the late 1960s, interspersed with further footage of Harrison from the mid-1990s. AI then had allowed the unfinished recording to be reopened in advance from its demo state. But it was important to reassure the public that this participated in a decades-old tradition of studio enhancement and did not constitute a new realm of AI fakery. Quoting McCartney, "We simply cleaned up some existing recordings, a process which has gone on for years," end quote. Now, the resistance to synthesis that we see in the press for Now and Then can be read as adumbrating a set of anxieties concerning the impacts of technology on culture and identity, and also on property. Lennon's and Harrison's sounds and images have been subject to all manner of posthumous modifications, and their music has been released without any of their consent, or either of their consent, even in the face of overt protests from Harrison. But it's important to maintain the illusion that amongst the play of artifice and verisimilitude, the voice, Lennon's voice, has been left intact. Now, few sound scholars would countenance an analysis of vocality that doesn't admit mediation and mediality as a kind of starting condition. Ideologically, voice imputes a simple identity with its subject or its source, as in the metaphor of voice as a sonic fingerprint. But voices, of course, change in the bodies of their carriers, in the worlds they extend to, and in the media that transport them. Catherine Maitzel asserts that one body can generate many voices, to which Jonathan Stern has added that one voice, and indeed multiple voices, can generate many bodies. Reassuring the public about the special restraint that Lennon's voice enjoyed in the mix thus participates in a vococentric imaginary in which the play of remix and recombination is suspended when we get to that sort of bandwidth that represents voice. But there's another dimension to the Beatles statements, and this is one of voice as property or asset. Much popular commentary on vocal cloning technology has hinged on the question of whether identifiable voices can or should be protected by copyright. Think pieces on the topic often conclude that advances in deep learning call for new laws protecting musicians from the risk of fraud, or for holding to account powerful individuals who may claim that genuine footage of them is deepfaked. In an essay on the modernist playwright Antonin Artaud, Jacques Derrida makes the opposite claim, not that voice is in need of new protections, but rather that the very concept of property issues from the ability, stroke inability to assert, this is my voice. Derrida's argument hinges on Artaud's hatred of speech prompters on stage. Artaud believed that these prompters rendered performing bodies as submissive vessels, dutifully acting out the instructions of a foreign text that preceded the here and now of the performance. As he wrote, quote, Artaud knew that all speech fallen from the body, offering itself to understanding or reception, offering itself as spectacle, immediately becomes stolen speech. Theft is always the theft of speech, of text, of a trace. Note, of course, that it's in the impossibility of establishing a kind of full identity between speaker and voice, in asserting full possession of this kind of sound event that lies closest, that for Derrida, this propertied relation inheres. Of course, for the Beatles, the dilemma around voice theft comes not from any affinity with Artaud's ideas about theatre, but from the need to distance themselves from the many thieves proliferating simulated pop around YouTube and TikTok. Using commercially available source separation packages similar to MAL, amateur studio producers have been isolating vocals on tracks to create their own models of pop stars, whether to have them perform implausible covers of other music, Michael Jackson singing Bohemian Rhapsody, for instance, or to use as so-called style transfers for their own voices, as in the case of Ghostwriter's fusion of Drake and The Weeknd. Strictly speaking, vocal models complicate the sampling versus synthesis distinction that underwrites McCartney and Starr's assertion about which parts of a multi-mediated recording count as truth and which artifice. But suffice to say, the insistence on the integrity of Lennon's recorded voice keeps at bay the possibly horrifying possibility that through synthesis, the Beatles could continue on forever. It's from this that, again, drawing on McCartney's quotes about the record, we get the quite bizarre assertions that this is the last time ever that you will get the four Beatles on a track. But if we loosen the moral reins around ownership and theft and consider both the Beatles and the bootleggers as thieves, albeit not perhaps partners in crime, then one could question how different Now and Then is from the bootleggers' own AI-powered reanimations. In one of the most successful of these, anonymous producer Day Limbs has reopened McCartney's Return to Pepperland, the centerpiece of an abandoned solo 1987 album that was originally recorded with producer Phil Ramone. A favorite of die-hard fans, Return to Pepperland is written in the psychedelic style of Sgt. Pepper, but carries the production characteristics of Ramone's work with Billy Joel and Paul Simon. Day Limbs' completion of Return to Pepperland takes the voice and piano from the track, but adds new parts bearing George Martin's production style for Sgt. Pepper's from 20 years earlier. So George Harrison's thin guitar sound, simulated call and response vocals, simulated brass, and it also borrows a drum beat from the song Lovely Rita. Similar to Now and Then, it can be seen as fulfilling the promise of the earlier unreleased song, taking a demo by one of the Beatles and presenting it as a Beatles release. Its only difference technologically is that its play with audio signals continues to the voice, using newly generated harmonies that are sung by the producer himself, using style transfers of Lennon and Harrison. YouTube comments under Return to Pepperland show the many hundreds of YouTube users who've heard this bootleg as superior to the Beatles' back song that currently sits at the top, well, sorry, no longer sits at the top of the UK charts, but did reach the top of the UK charts. Indeed, the response was so enthusiastic that it prompted Day Limbs to issue a pious disclaimer, writing, I've been getting tons of comments recently saying people prefer my version to the Beatles' Now and Then. While I appreciate that people think so highly of my work, truly, I think it's important to remember that while the stuff sounds legit, it's not the real thing. Let's take a moment to appreciate the fact we just got a new Beatles track in 2023 and it sounds freaking amazing. Now, questions of value here are obfuscated, I think, by the mystifying concept of AI, which can refer to anything from the automatic generation of an entire piece to the mastering and finishing of a track. What AI obscures is a blunter issue, which is simply that McCartney's Return to Pepperland is a better song than the drab Now and Then, which was released in November. Put differently, we should ask not whose AI is better, but who is the better curator, judge, and finisher of the Beatles' unreleased output, the group themselves or the fan subculture. Notwithstanding all of this, it's intriguing that in responding, Dalims exhibits the same moral anxiety about AI as the Beatles do, terming his own reconstructions fake and the Beatles one real. Now, some of it, the bootleggers' AI simulations have fallen foul of YouTube's recently expanded Content ID, which can create deepfake simulations of copyrighted work. However, many of the best ones tend to focus on unofficial recordings that are not commercially available, which means both that there's often not an original rights holder for the algorithm to find, and that a case for fair use duplication could in theory be made on account that it keeps in circulation a recording that was not otherwise available. This then is a legal grey area that's being negotiated and explored as we speak, as Georgie and Eric's presentations highlighted. But within this, it's striking to observe the development of moral norms around the use of vocal clones among the bootleggers. As the following video shows, bootlegger Bookoff Smile, which is another pseudonym, echoes Dalim's sentiments in describing the ethics of the release of one of his own models of Brian Wilson. I shall play this now. Oh dear, hold on. Playing the sounds. Okay. I think the best thing to do is if I just read the quote. Yeah, we won't listen to Bookoff Smile relating his anxieties about this. So Bookoff Smile says, if you're going to use this Brian Wilson voice model that I worked tirelessly on, please create real art with it. I don't mean real art as in real art and fake art. I mean real as express something. Use it to bring love and joy to the community. Don't use it to get views. Don't use it to create clickbait. Don't use it to just pump out 100 things because you think it would be interesting. Now, other than Bookoff Smile's pleas to camera, his strategy for managing the sheer power that his models might unleash has been to release them in a piecemeal state. He reasoned that since users would have to install various libraries to get them running, only committed users and producers would bother. A different approach to the problem of clickbait overload has been trialed separately by experimental pop musicians Holly Herndon and Grimes. Both artists have released open source models trained on their own singing voices, which are free to use by any user. However, certified users have to acquire a stamp of its external legitimacy. For Grimes, anyone wishing to make commercial music using a voice model must acquire a license, which is granted by Grimes herself, and which states that Grimes must take a 50% share of any revenue generated. Holly Herndon's Holly Plus is similar, except approval comes not from Herndon, but from a distributed autonomous organization, which consists of 20 stewards who are chosen because they are, quote, invested in maintaining the value and reputation of my voice, end quote. Authorization in this case entails an artist uploading a song that they've created with the Holly Plus model and submitting it as a proposal to the DAO through a public interface. After this, the DAO members vote on whether to mint the song as an appropriate or inspiring usage of the Holly Plus voice. If approved, an NFT of the song is minted by the DAO, with 50% of sales going to the artist, 40% going to DAO members, and 10% reserved for Herndon. Herndon's model moves beyond the idea that the artist themselves is the best steward of their own likeness and oeuvre. However, since the DAO is comprised of collectors, friends, and family, it's not that far removed from the extended patrilineal network that certifies the Beatles Now and Then as an authentic deepfake. The DAO may not then be the best quality valve in this case. Grimes and Herndon's platforms refer frequently to appropriate, good, and inspiring uses, just as Bookoff Smile talks about real art as opposed to clickbait. But if we reframe the good, bad, appropriate clickbait dichotomy as pro-amateur, then we open onto another potential future for artist voice models besides Grimes and Herndon's interventions. It's not impossible to see rights holders teaming up with the audio software industry to produce certified artist voice models as software packages that are accessible not on the criteria that you make great art with them, but on your ability to pay the pro subscription fees. Could this be a future for vocal cloning that they're made legitimate by a kind of commercial enclosure? A case from the recent past may be instructive here. 20 years ago, the first generation of Vocaloid synthesis packages debuted at trade fairs to much industry excitement. Like vocal clones, Vocaloids are created via hybrid sampling and synthesis signal processing method. Here, it involves concatenating samples of vowel and consonant combinations that are recorded by individual session singers, and then these are assigned a kind of virtual identity. Differently to style transfers, Vocaloid avatars, or fonts as they're called, are generally virtual identities or characters or avatars, as in the case of Hatsune Miku. An exception to this, however, was Miriam, the vocal font based on a model of British singer Miriam Stockley. At the time, the trade press reported on Stockley as a trailblazer in artist music tech partnerships around digital likeness. In a press release from 2003, she was reported as saying, "At first, I was quite horrified by the idea. People tend to pay a lot of money to get my sound, and here I am putting it on a font." She changed her mind, however, because, quote, "You can't fight progress no matter how strange it sounds." After Miriam, music industry commentators speculated on where this might lead and whether big name artists would follow. But Stockley remained the only identifiable Vocaloid, as far as I'm aware. The reason for this, or one reason for this, comes down to the industry in which she worked. Stockley first gained exposure in an industry where rights are concentrated in the interests of songwriters and producers who are largely male, at the expense of singers and session musicians who are often female. First as a session singer for Stock Aitken and Waterman, and then as a vocalist for the 90s electronica duo Praise, Stockley was one of many familiar but anonymous voices that circulated within the transnational Eurobeat genre. Rather than a post-human gesture of cyborging her identity, the Vocaloid partnership offered a way of proactively asserting some authorial and economic control over her vocal likeness against its de-individualization in the studio. Reading Stockley against the contemporary cases of Herndon and Grimes, it's impossible to ignore the gendered nature of kind of enterprise and innovation in voice loaning. Grimes and Herndon are different to Stockley in the sense that they're stars, but they still represent attempts to get ahead of the game in an industry that historically has been exploitative of women's voices and labor. Around the time Miriam was released, Michael Stipe was amongst big name artists who reportedly declined to donate their voice. Today, incentives for big name artists to lease their voice to digital studios, digital studio users remain about the same. As such, it seems unlikely that Brian Wilson or Paul McCartney will follow the lead of Grimes and Holly Herndon. Instead, the likelihood is that platforms like YouTube will continue to expand their powers to outlaw unofficial content, democratize artist voices, and as Eric mentioned, Synth ID seems to be likely to be a consequential kind of technology in this. Perhaps this will signal the end for the bootleg communities currently surpassing their idols in remastering their back catalogue, as one channel of industry-threatening abundance is blocked. Or perhaps they will find a way into the nostalgia industry of rarities and bootlegs as kind of partners in crime and equals legitimate AI voice engineers who are hired by studios. The desire to not set themselves up as competitors to the Beatles, as we saw in Dale Ims's comments to his YouTube public, suggests that some of the bootleggers have that in their sights. So to make some concluding remarks, just generally, a speculative question, a key speculative question concerning copyright and IP for this panel is in relation to simulated pop is one of value. If the bootleggers' creations have value for their listeners, and it's clear they do, then how can that be preserved and not destroyed by the movement towards enclosure and de-democratization by the corporate platforms and their industry partners? I've outlined some of the problems that this question issues force, as well as some of the limits with DAO and NFT-based responses to this. But as always, the hardest work lies in offering more practicable kind of solutions. Short of making proposals for innovative new forms of copyright that might protect simulated pop, a positive intervention that could be made and that falls within the deep domain of musicology is in the genre's discourse and appreciation. The pejorative language of deepfakes and clones is arguably a quite poor place to start if we want to advocate for the worth of some of these deepfakes as musical practice. As a cultural technique of recorded music, deepfakes share affinities with hip hop and sampling, of course, but the contrasting ethics of engagement and creative license make that comparison harder to hold in certain cases. Some have turned to the language of fan fiction and homage, and there's certainly merit in that association, although Ghostwriter's simulated collaboration between Drake and The Weeknd, which is the most famous instance of deepfake pop, is poorly described, I think, by that. In a 2021 article, Ezekiel Dixon Ramon and Raymond Amaro discussed deepfakes in relation to hauntology, which seems a reasonable enough critical starting point for a discourse on simulated pop. Hauntology places simulated pop within a recent history of kind of uncanny sampleodelia that's interested in qualities of simulated memory and deja vu. And it also brings us back to Derrida and the questions of ghostly spectral resonances in the concept of possession and property. So with that, I will close and open to questions. Thank you very much.